Hello everyone, welcome to Court with Krissy. I've got an update. You remember that one pro se that tried to disqualify Judge Cooper before he retired? Yeah, that guy. Well, he's back, and this time it's before Judge Hesselink, aka Bossman. It gets worse. As always, if you happen to miss the first appearance, link is in the description as well as in the video. I hope you like it. Court with Krissy is now in session.
The next case is Jam Exploration versus Matthew McFerrin.
Good afternoon, Judge Elliot Blumberg on behalf of Jam Exploration.
Good afternoon, Your Honor.
Afternoon, Mr. McFerrin. We adjourned approximately a month ago for you to submit some amendments to your motion to dismiss to qualify under the court rule. To be more specific, have you done that, sir?
No, Your Honor.
Why not?
We don't think this is even going to get to trial.
I'm sorry. When the court asks you to do something or tells you to do something, typically you don't get to say, well, I don't want to.
What were you wanting me? We're not going to recuse you, Your Honor. So I don't know why you want.
There was two things on the table from last month. One was a motion to disqualify me if you wanted to, and I understand now that you don't want to, and that's fine. But the other one was a requirement that on your motion to dismiss that you specify under which part of the court rule you were bringing that, so that Mr. Blumberg had a proper opportunity to argue that, and the court knew what level of scrutiny to bring to it. Under the court rules 2.116 subsection C, there's a list of various motions for summary disposition. And some of them involve just looking at the pleadings, and some of them involve looking at the affidavits or evidence. And so the court needs to know which one of those that you're proceeding under.
Right.
So I wanted you to specify those, because Mr. Blumberg's entitled to know those, because there's different arguments to be made for different types of hearings. So I was inquiring whether or not you did that.
No, Your Honor. And if you do remember, we were kind of backlogged that day, and I think we were in a little bit of a rush, and I apologize for any misconception there on my end as far as my dismissal. But we have some other concerns that we think are more prevalent than the issue at hand that you just
well, I don't have anything else in front of me today.
Well, Judge, we had filed a summary proceedings for an eviction of Mr. McFerrin and all of his parcels that he had been leasing. He hasn't made a payment in over 2.5 years. We filed this case seeking to recover possession. He filed a motion for dismissal. You gave him 30 days to amend or correct or do something, which he acknowledges he hasn't done. There have been no defenses provided by Mr. McFerrin that would stop the recovery of possession.
Objection, Your Honor. That's equivocally false. I filed statements with Mr. Blumberg explicitly with his accusation that we haven't paid. In fact, Mr. Blumberg's accusation of non-payment is probably going to catch him a defamation lawsuit, as Mr. Blumberg and I both agree that the last payment was made in May of 2022. His client mailed me back unopened the payments for June and July, and then his client mailed August's payment back.
All right, hang on, Mr. McFerrin, hang on. We're getting way too far ahead of ourselves at this point. So let me just back up and say this. I want to make sure I understand each party's thing. So I'm going to ask some very pointed questions of each party. So I don't want either side going historical on me or making allegations against the other one. I just want you to answer my specific questions. So, yes. Mr. Blumberg, as to this summary proceedings, it's my understanding under the statute that you may only recover possession by proceeding under this where there is an executory contract, if the terms of the contract expressly provide for termination or forfeiture. Where in the contract does it provide for that?
Your Honor, we haven't been provided any contracts, and it doesn't say that.
Okay. All right. I'm again, Mr. McPherson, that question was for Mr. Blumberg. I'm going to have some questions for you, or I may, depending on how Mr. Blumberg responds, but let me just hear from Mr. Blumberg first.
Judge, the document in question is an option to purchase unimproved vacant real estate. It is a lease with an option to buy. Mr. McPherson did not make the payments required to even attempt to exercise his option. So he is a tenant that simply has not made the payments. He's like any other tenant in a landlord-tenant situation until such time, if ever, is that he met the requirements, made a written request to exercise the option. So, to answer your question, this is like any other lease. You don't need to have express language to evict someone who doesn't make his payments.
My problem with that is I'm looking at MCL 600.5726, which says that proceedings under this chapter, which are the summary disposition, is the summary disposition chapter, after the forfeiture of an executory contract, but only if the terms of the contract expressly provide for termination or forfeiture, or give the vendor the right to declare a forfeiture in consequence of non-payment of monies required to be paid under the contract. So I believe that if you're going to file it in district court under the summary proceedings, I'm required to follow this statute, which says that you only can do that if there is an express term in the termination.
Judge, someone else is talking and I can't really.
I can't hear your
Whoever has their mics on, please mute yourselves so that it's not bleeding into the court record. Thank you. I believe the court staff has done it. So let me repeat that. I believe that I am required under the summary proceedings statute, which the specific one that I'm citing is MCL 600.5726, to only allow summary proceedings where the plaintiffs are entitled to it. And this says that a person entitled to any premises may recover possession by a proceeding under this chapter, which is the summary disposition chapter, but only if the terms of the contract expressly provide for termination or forfeiture, or give the vendor the right to declare a forfeiture in consequence of the non-payment of any monies required to be paid under the contract.
Judge, that language.
If there is no express, I'm sorry, but let me finish. If there's no express contract language, you may be entitled to proceed in circuit court on that, but I don't believe that you're entitled to the summary proceedings in district court on that. And I'll hear argument from Mr. Blumberg as to that point.
I think, Judge, the language that you were reading from applies to land contracts where there is a vendor and a vendee. That's not what we have here. This is a simple landlord-tenant situation. And certainly the court has allowed eviction proceedings where a tenant doesn't pay rent, or even if it's a holdover tenant that doesn't pay rent. I think the language that you're referring to would apply if this were a land contract and we were seeking to forfeit the contract. Then you would need express language that allowed for the forfeiture. This is, again, a landlord-tenant situation where we're simply seeking to evict for non-payment of rent.
I don't see any landlord-tenant language or rental language in the option to purchase. This is an executory contract. It's an option to purchase the right to purchase the property. So it's an option contract, which is in essence a land contract.
No, again, Judge, with all due respect, I don't mean to
objection, Your Honor.
Mr. McPherson, let me hear from Mr. Blumberg. If I need to, I'll contact you. But right now,
I appreciate it.
Thank you. Go ahead, Mr. Blumberg. I'm all ears because, as you know, you have more experience in this area than I do. So enlighten me.
Well, I'll try, but then I don't know that I have that much more than you, Judge. But this contract, this document becomes a option contract if and when only the tenant, Mr. McPherson, meets the obligations of paying rent. And then he has to, in writing, make a declaration of an intent to exercise the option. He never got that far. 2 years into the lease with the option to buy, he defaulted by stop making payments. He's right. He didn't make payments, but then when he tried to start making payments, those payments were returned to him after he'd already received a letter notifying him that the tenancy had been breached by his non-payment. So again, I didn't draft this document, but and I've somewhat struggled with some of the language in here, but I think a close reading of it, and it's probably not fair for you to look at it just now and come to the conclusion that I think you should, but this is simply a lease with an option to buy. The option was never exercised. So consequently, this isn't a land contract. It's a lease with an option to buy. The option was never exercised.
And I do appreciate that, the explanation. And I have more than just right now looked at this. I've spent quite a bit of time in the last month mulling this over and reviewing it. And I simply see no place in this option. It's entitled an option doc or an option to purchase unimproved vacant real estate. I see nothing in there that talks about a lease, a rent, or tenancy. This is a contract to be able to purchase land. And there is a section under paragraph 6 of each of these individual contracts that says during the period that this option remains in effect, optionee shall have the right of access to the option property for purposes of investigation and camping, and shall have the right to set up temporary camps to hunt the property. So there is, that's the only aspect that I can find that would be similar to landlord tenant, but it still uses the phrases option and optionee and optionor, which is contract language as opposed to landlord tenant language. And it doesn't say anything in there about length of the lease. It just says you're going to make payments. And once you're done with the payments, then you have 30 days to put in your option to purchase. And so this is a contract to purchase land.
It would be that if, in fact, under paragraph 3, if the option is exercised, there shall be credit given on the purchase price of an amount equal to that which would attribute to principal. So the rents, once you pay all rent and you declare your decision to exercise your option, all the rent payments are then applied to the purchase price. Again, not as I would draft it, but that's what the document says.
But it doesn't say rent.
No, but everything. I'm sorry, I don't mean to cut you off. I apologize.
Sorry, go ahead. Go ahead, sir.
I was going to say all the money that's paid prior to the declaration of exercising the option, that's rent. It becomes payments towards the purchase once the option is exercised. That's what it says.
Where do I find the authority for calling it rent? Because the document itself doesn't call it rent.
Well, but what else? You're right. It doesn't use the terminology rent, but what else would it be? You're making payments towards the ability to purchase. Let's take this of this case. Mr. McPherson signs these documents, and there's 5 different parcels that he's signed these to, and he starts to make his payments, but then stops well before the payments are paid in full. What would be the remedy? I guess the court's suggesting at that point, if it's a land contract, we have to go, well, we still can do that in district court though. Then we forfeit the contract. But our position is it doesn't become a land contract until such time as the option is exercised. And that requires him to make all the payments, which he admits he hasn't paid.
I'm not having any problem at all with what you just said as far as if he hasn't done the future. We're going to option this. We're going to do this option to purchase in the future. I don't have any problem with that. We'll get to whether or not he's tried to make payments and you refuse payments. That's a future thing. Right now, I think the only way that I can find that you have the right to summary proceedings, which is what you've asked for,
right,
is if the contract, if this language is in there, and I don't see this language in there. I don't know of any legal requirement that I term the payments as rental payments. I believe that they are a contract-based payment for the right to exercise purchasing in the future. That's my understanding of what an option contract is.
Well, no, except once you have to exercise the option to have it considered.
And he hasn't done that yet. He has not done that yet. So if you may be entitled to forfeiture.
Well,
but I don't know if he
exercises the option. I'm sorry, I apologize for cutting you off. There's this delay.
My question is whether you get to do it now under summary proceedings or whether you have to wait for the future to not do it under summary proceedings. I don't know. I don't believe that I have the authority as a district court at the moment to give you what you're asking for. Not to say that I might not in the future under a different type of proceeding, but under the summary landlord tenant things, there's supposed to be an express. That's why it's supposed to be summary, because there's a contract that already lays out all of this stuff. And this option contract doesn't do that. That's why summary proceedings are summary, that they're supposed to go quick because you've already got all that language there and they're already put on notice as to what's going to happen if they don't do what they're supposed to do. Unfortunately for you, you're stuck with the contract as it's drafted. And I understand you probably would have drafted it much differently than you're stuck with now. My belief is at this point, unless you have some authority that says that payments under a land contract or similar to a land contract amount to rent while they're being paid until the land contract option time occurs, I can't give you summary disposition. I can't give you summary proceedings at this point. You'd be stuck with land contract forfeiture proceedings, and I'm not sure if that's district court or circuit court at this point.
Well, so, and again, I'm following what you're saying. My question is, at this point, 2.5 years of non-payment, based on the court's analysis of this document, I think we can agree, if the facts support it, that there's been a breach of whatever that is, whether it's non-payment of rent or non-payment on a land contract, if the court sees it as that. So, but the court does have the authority, certainly, to do land contract forfeitures if it's the court's view that that's what this is. And again, I respectfully disagree. I don't think that that's what this is. Obviously, I'll accept whatever your ruling is. I just need to know in what direction to go.
Yeah, and I certainly understand that. So at this point, I'm going to say that it is what I've put on the record, that this is a should be properly done under the land contract forfeiture and not under the summary proceedings under landlord tenant. My thought is because there hasn't, and again, I agree, I understand, Mr. McFerrin, that you disagree about whether or not payments have been tried to be made or whether you stopped making payments, or I understand the parties disagree about that. So my thought is, while we
Your Honor, can I speak at all?
Hang on. What is it specifically that I need to know at this moment to deal with the issue of whether this is a summary proceeding or a land contract forfeiture proceeding?
Well, the very first hearing we had on this case, Mr. Blumberg's opening statement was he didn't write these and he doesn't know what they are. Beforehand, he sent me land contract forfeitures. Now we're into a lease to own. I don't know if Mr. Blumberg really knows what he's arguing. We keep moving the goalpost, and we can make payments. We can pay. And so the option to purchase, when the payments were stopped, when they stopped taking them, was $120,000. The land value was $300,000. We entered into a real estate transaction.
Objection, Judge. These are all
Mr. McFerrin, you're going way off in a different direction than my question was. My question is only right now, which type of proceeding are we here on? And does Mr. Blumberg have the authority to proceed under landlord-tenant law? My ruling right now, or what I'm leaning towards, is to say, no, he doesn't have the right to proceed under landlord-tenant law. He may have to proceed under land contract forfeiture law. So that's the only thing I'm worried about at the moment. So that's where I'm going to enter an order that says that Mr. Blumberg's not entitled to summary proceedings under landlord tenant law, but he can amend his pleadings to ask for forfeiture under land contract law. My understanding of land contract law is that during the pendency of the proceedings, if one of the parties is claiming that they can or should be allowed to make payments, that there is that the monies can be held in escrow for that purpose. Mr. Blumberg, would that be of assistance in your proceedings or not?
No, Judge, it really wouldn't, because the owners of the property sent out notices to Mr. McPherson on all of these parcels about the default that was entered for his non-payment. They, at that point, had no obligation to accept late payments.
No, that's false.
All right. The question becomes whether or not there is then an implied duty to accept payments. If Mr. McPherson is arguing, and I believe that he has, that he tried to make payments and that the plaintiffs have not accepted those payments, I'm going to have some sort of an evidentiary hearing on which one of the two sides is correct. If he has tendered payment and is ready, willing, and able to tender payment, in my mind, that may be a good defense to this. If in fact he has not made payments, and there was a reason why he, once you made the notice to quit, you're correct. You're not required to accept payments on that behalf. So I need to know when and under what circumstances the payments were either stopped or not paid.
Judge, again, there's no language in this document that talks about curing any defaults. Again, if we're going to say this is a land contract and he doesn't make his payments on time, generally contracts do have provisions about, curing 10 days, for example, to cure any defaults. That's not the factual case here. And again, I guess we don't have to argue that. I understand your ruling. So I guess with the court's blessings, we'll file an amended action for a land contract forfeiture.
And with that, Judge, I need Jam Exploration's Michigan Mortgage Originator's License, if possible, because there becomes an argument whether this is even legal versus the Frank-Dodd Act of 2016.
All right.
So,
you have the right to ask for discovery from Mr. Blumberg.
For sure.
That's part of that process. So if you want to ask for discovery, you can certainly send written documentation to Mr. Blumberg asking for whatever discovery you think is appropriate. Mr. Blumberg, how long do you anticipate you would need for the landlord-tenant the land contract amendment of your complaint?
I would say ask for 14 days.
All right, that sounds reasonable. Mr. McPherson, you would have an additional 14 days to file any response to their complaint, any additional defenses that you want to add, any additional counterclaims or claims as well.
Correct.
So I'm going to give you each 14 days.
Your Honor, before we go, I had some individuals go out to the property to remove snow from the rooftop of the buildings out there that I had built. And it appears that one of the neighbors called the state troopers or the sheriff's department and claimed that there's a eviction order on me and that we were trespassing and that my guest had to vacate the property that night. And is there any order or ruling out of this court regarding that? And we also have a couple access and easement issues. Not only are we paying for property, but part of the property has a legal description and a land description, and part of the court officers and the courts don't agree with that. And that seems to be the binding issue right here is we can't get a bank loan with the known access and easement issues that are going on. And so that's another issue that arises because we have about 60% equity already paid down on the property, and we can convert that into a regular mortgage, but we have issues with access and easements that are noted in the county for the last 6-7 years. So,
Mr. McPherson, it sounds to me like you need an attorney to advise you on all of those issues.
I wish you were still around.
Your legal counsel.
I wish you were still around, boss man. So.
Oh, Judge, okay. Never mind. I guess, clearly Mr. McPherson has indicated that you had represented him in some easement issues in the past. That's not a part of this lawsuit because, and for that reason, I hadn't thought twice about asking you to be disqualified. I know you can be fair and impartial, but if he's going to try to bring in those issues that you represented him on, then that might cause a problem. Those issues are not for this court.
I'm sorry, let me just state for the record, I represented him on personal protection order issues. I did not represent him on any of the land issues. And so I just simply want to state that I have no dog in this fight. And Mr. McFerrin,
I'd object to that, Your Honor.
Mr. McFerrin, please keep this case professional.
For sure.
And keep it, if you have an issue, like Mr. Blumberg has an issue, put it in writing. I'd be happy to consider whether or not there's any issue there where I need to recuse myself. But at this moment, that's not before me until you guys formally do so. Put all your issues in writing. And if you're going to ask to recuse me, then I'll consider it. And it'll go up the chain of command after that. But we're not going to refer to each other as boss man or anything else. I'm the judge in your case. You are one of the participants in the case as a party, and we're going to all treat each other with respect. So the end of this matter today is Mr. Blumberg is going to have 14 days to amend his complaint. Mr. McFerrin is going to have 14 days to answer or respond if he wishes to, and we'll be back here in a month for the next part of this court hearing as to where we go from here. Thank you all very much for today.
Thank you, Judge.